views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
All right, coming up on this edition of Today's Verdict, patients put much trust into the dentist they choose, but unfortunately mistakes in the dental field can occur as often as any other medical malpractice. We look at a few common dental mishaps on tonight's episode. Next up, as an employee, you expect to receive the wages that you work so hard to earn. But have you been paid for your overtime? And do you have a right to look to back pay? It's wage and hour law, and we have you covered. Finally, racial harassment is a specific type of discrimination that has been in the news as of late. There are civil and criminal remedies, and we discuss both tonight with an attorney who specializes in the field. As you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. All right, hello and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesh. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us at Today's Verdict and check us out at BronxNet.tv. Usually when we think of medical malpractice, we think of doctors making a surgical, medication, or diagnostic error. Patients rarely think of mistakes made by their dentist. Dental malpractice can be as dangerous and costly as any other type of medical malpractice. Well, tonight, attorney Jeffrey Rich joins us on set. Jeffrey, thanks for being here.
Thanks for having me.
Is there a different type of relationship that people have with their dentist than, let's say, their orthopedist or their cardiologist? Do they ask as many questions when they decide to pick their dentist, or they just jump right in there?
Well, that's a good question. Some people have long-term relationships with their dentists and probably discuss more things with them than they would with an orthopedist or a cardiologist. Others in different communities don't really have the same types of relationships because they don't administer dental care to themselves on as frequent a basis.
But certainly you would think, you know, that there are so many mistakes that are made in the medical field that in the dental field, maybe you would just trust your dentist a little bit more and not even ask, do I really need this? Is this okay? But as you're here to tell us, there are many mistakes that are made in the dental field. Am I correct?
Oh, absolutely. Interestingly, just like in any other field of medicine, dentistry requires the patient to be fully informed and to consent to any procedure that the dentist might be doing. Typically, the process involves advising the patient of all the risks and benefits and alternatives to whatever the procedure might be.
Is this usually done in writing, or is it done while the patient is sitting in the chair and they say, look, I think I'm going to do an implant on you right now. Are you okay with that? Or do they then give you a piece of paper that you sign when you're there, or how does it usually work?
Well, it's interesting. It's interesting that you ask, because I would say probably 75% of the time, most practices that are doing oral surgery, which an implant procedure really is, will have some form of written informed consent to give to the patient. A lot of times, I'd say 25% of the time, we have cases where there's absolutely no written informed consent, and the issue becomes basically a he said, she said between the dentist and the patient as to what was...
Which brings us to the records, and as you and I know too well, many times the records don't accurately reflect what the patient told the doctor to do, or what the doctor told the patient he or she was going to do. And I think that probably becomes an issue at trial as well.
Oh, certainly, and at deposition. And oftentimes when there's an injury that's serious, and we can talk about the types of things that happen to people if you want, the records, I don't want to say can be doctored, but sometimes the records are different following an injury.
But you can say doctored, to be honest with you. There are times, and it wouldn't be the first time, but there are times that records are changed after the malpractice occurs.
Right. A lot of times we see records that are either rewritten or written in extensive, excruciating detail following an incident that occurs to a patient. For instance, back in the day, and still a lot of times these days, we see handwritten dental records, and typically for each office visit, you'll get 2 or 3 lines of scribble. But on the day when an alleged dental malpractice incident occurred, you're going to see, meticulous handwritten notes that you could actually read that are probably, 2 pages long.
Exactly.
So
All right, let's talk about some of the dental mistakes that you've seen in your practice.
Well, the most harmful dental mistakes that we see are the ones that cause nerve injury. And typically the nerve injuries are injuries to the 2 nerves that are part of the lower jaw, which is called the mandible. Mandibular nerve injuries occur usually during dental implant procedures when a dentist either drills too deeply or places the implant too deeply and affects a nerve called the inferior alveolar nerve. Sometimes during lower wisdom tooth extraction, you have injury to a nerve called the lingual nerve. And those nerve injuries usually have to be treated by surgery by a microneurosurgeon, so they're quite serious, and they result usually in a lifetime of bad pain.
Does the patient know that there was an error that was made? When do they realize that there was actual dental malpractice? Is it the surgeon? How are they diagnosed? How do they know there was an error with respect to the dentist?
It's a great question. For instance, with regard to these nerve injuries that I just mentioned, when everybody goes to the dentist for a procedure, such as to get a tooth either filled, to get a tooth extracted, or whatever, you're going to have an injection of anesthetic that goes and numbs out the nerves that we just discussed, so you don't feel what the dentist is doing. Typically, when there's a nerve injury to one of those nerves, the patient realizes that the anesthesia is not wearing off, and they feel numb 5 or 6 or 7 hours later, or they feel numb the next day, or they feel numbness and pain in some form of combination. And that's typically how they're alerted to the fact that they may have a nerve injury.
Let's get into the law part a little bit here. There's a certain time limit that these patients have, the plaintiffs have, to bring the action. Let's talk a little bit about that so people understand. Okay. You don't have forever to be able to bring a dental malpractice case. How long do they have?
Well, in most states, we have what are known as statutes of limitation. In New York, the statute of limitations to bring a dental malpractice case, David, as you probably know, is 2 years and 6 months following either the date of the malpractice or the last date of treatment with the dentist if there's some kind of ongoing and continuous treatment for the same condition.
Now, of course, what if it's a city hospital or something else involving maybe a municipality? Do they still have to file a notice of claim or some kind of way to ensure that you could bring an action against the city as well? Like it's the Harlem Hospital or something in that respect?
Well,
or does it change?
No, all the city hospitals are part of the New York City Health and Hospitals Corporation, and yes, there is a filing requirement for a notice of claim that has to be filed within 90 days following the incident. And typically the statute of limitations in municipal cases is 1 year and 90 days and not 2 years and 6 months. So it's a much shorter statute in municipal cases.
All right, now one thing that we had talked about off camera a little bit is that it's expensive to bring these types of actions. So taking the dental malpractice cases, are there cases that you might say, well, I don't think we can take this kind of case, it's just too expensive for us to handle, or is that really not the case?
Well, certain cases are very expensive to litigate. Other cases that involve common occurrences, such as we discussed when the dentist pulls out the wrong tooth, typically somebody's going to go to an oral surgeon, let's say, with a prescription from their dentist to say extract tooth number 18. And sometimes the dentist who does the extraction will take out 17, let's say, instead of 18. Those are molars on the left side of the lower jaw. And that's an example of malpractice that can't be defended in terms of the negligence, but the damages aren't great.
But if you do take a case, which you many times will, how do we find you?
Oh, you could find me by calling me at my office, which is 212-406-0440, or you can check out our website at www.richandrich.com.
Well, thanks, Jeffrey. Thanks for coming, and hopefully you'll come back, give us some more tips maybe in the beginning of the year.
Thank you, David.
All right, well, we have to take a quick break, but don't worry, we'll be back with more of Today's Verdict right after this.
Hamilton was adopted from a rescue in 2008. He's quite the pug about town. He gets invited to a lot of parties. He knows he's a pretty big deal. How could you not love him?
All right, welcome back to Today's Verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Are you an employee who has been cheated out of overtime pay? Do you know the rights you have with respect to wage and hour law? Well, no worries. Joining us today is attorney Michael Taubenfeld. Michael, this is a hot area in the law. I know that from clients who call my office. Many employees believe that they're not getting their fair pay for work they've put in. Am I wrong, or does this seem to be growing, certainly in the Bronx?
Absolutely, it's grown quite substantially in the last 10 or so years. There are studies that show that approximately now 10% of the court's docket in federal court in Manhattan is actually now wage and hour law.
But it seems like this has always been going on. I can't imagine employers haven't always been trying to, edge out the employees in terms of the bottom line, but we're not taking it anymore, it looks like.
It seems like at some point, maybe like in the sexual harassment field, people at some point just realized I need to do something about this, and they started bringing these cases, and attorneys started taking them, and the courts have become quite familiar with the cases.
Well, let's take a step back. Let's talk a little bit about the types of suits that are brought as a result of employees who feel that they've been shortchanged. Give me some examples, if you could.
So there are really two different types of cases. There's what's called minimum wage cases, and those are cases where someone was not paid a set minimum wage they were supposed to be paid. The general minimum wage, it differs in New York depending on how big the employer is as well as where the employer is located. Under federal law, the minimum wage is $7.25, so that's the minimum wage across the United States.
Can't go lower than that.
You can't go lower than that, right. There are actually some exceptions, but
But
as a
it's
general
basically
rule,
unconstitutional to pay somebody less than that kind of money.
it would be illegal, yes,
Okay.
generally. In New York, the minimum wage is much higher. New York, like some other states like California, they got on board the train for the fighting for $15 minimum wage. A couple of years ago, New York passed a law where they're trying to get a $15 minimum wage across the state. New York City right now has the highest minimum wage in the state. For an employer that has 11 or more employees, the minimum wage is $11 an hour, and it's going to go up to $13 next year.
Do people not realize what the minimum wage is? Is that part of the problem? I mean, does somebody walk in and then the employer says, I'm going to give you $10 an hour, and you're like, oh, that sounds good to me. Do people not know it?
I think there are a few different issues. There's some like that, absolutely. There are people who just don't know how high it is these days. There also are some people who they come here and maybe they don't have all their documentation, they're not necessarily authorized to work in the United States. Now the law protects those people, and if they bring a case, their immigration status is completely irrelevant. But nevertheless, of course, they're worried about reporting, so they often get paid less than the minimum wage. And they have some people who are just working off the books, which they're also protected by the law.
Right, but well, I mean, you shouldn't be working on it. It's illegal to be working off the books, but they do, and then I guess the employer says, I'll pay you $9 instead of $11. I'll give you cash, and that's
well,
the
it's
issue.
not necessarily, I wouldn't say it's illegal to work off the books. It's more illegal to hire someone off the books.
Okay, that's fair.
That's probably a better way to put it.
The second main type of area is overtime.
Right.
That's the big one.
That is a big one, yes.
Give me an example.
So I would say the best example is people who get salaries. There's this misconception that if you get a salary, you don't get overtime. You're exempt from overtime. And that's somewhat true. There are definitely people who get salaries who are exempt from overtime. But getting a salary by itself does not mean you're exempt from overtime. So if you're working, let's say, in a kitchen in a restaurant, and you're just a line cook, and you're getting paid $700 a week even, you're working 50, 60 hours a week, you're supposed to get overtime. It's not enough to pay those employees the $700 a week.
And what is typically overtime?
So overtime is anything more than 40 hours in a week.
And what do you paid? It's time and a half, am I correct?
It's time and a half.
So these suits that are brought, they're recouping the time and a half for each hour over above, and do you also get penalties? I mean, what are you getting from this? Really?
Right, so for overtime claims, if you got paid, let's say you're getting paid $10 an hour, let's say you're in a place where that's okay, like Westchester, and you work 50 hours, you get paid $500. Basically, you should have been paid an extra $5 an hour because time and a half is $15.
Sure.
So you bring the lawsuit to get the $5 as well, and you can also, included in that suit, you also ask for what's called liquidated damages. And liquidated damages are essentially 100% of what you should have been paid. So if you're owed $100 in unpaid overtime, you're entitled to get another $100
Additional.
as liquidated damages. That's true also for minimum wage as well.
So where do you see, because I know you do these types of, you process these types of claims. What fields can you tell us that you see this happening the most in? Is it people who own buildings and maybe with porters and superintendents? Is it, I don't know, your neighborhood McDonald's? Where does this occur, really?
I would say there are a lot of different fields, and those are good examples. Restaurants is probably the most common one. You have people who either waiters and they're not getting paid. And waiters can be paid less than the minimum wage, but there's certain requirements that have to be met. But often they won't get paid anything at all; they'll just get tips.
Tips.
That's clearly illegal. You have people working in the kitchen getting paid salaries, like I just said. Those people would have claims for overtime.
Okay, let's get into the law itself in terms of the claim. What's the first step? Is there a particular agency you have to file with? What do you do?
So there's no requirement to file with an agency, like in certain other areas. You can file directly in court. You could either file in federal court or you could file in state court. Generally, most people file in federal court because the judges are at this point, so familiar with the cases, and federal court tends to be a quicker process.
Do you usually get a better verdict or a better settlement in one of the particular venues, or does it not really matter?
Verdict shouldn't really change because ultimately we're talking about math.
Okay.
I mean, how much you owe, that's really it. When it comes to settlement, if the case moves faster, typically that leads to a settlement quicker. That's just the general rule.
All right, and is there by the way, is there a statute of limitations or anything, and or does it change whether it's federal or state? How does that work?
There's a 2 or 3 year statute of limitations under federal law. The 3rd year is added on if you can show that the violation was willful. Under New York law, it's a 6-year statute of limitations no matter what.
Oh, so that's a lot of time.
It's the lengthiest statute of limitations I think there is.
Which is not so good for employers.
Not so good for employers, but it's important for them to keep track of the law and pay people properly.
Okay, some tips. Michael, someone's watching right now. They think they may have a claim. They're not quite sure. What would you tell them to do? First thing you tell them to do.
It depends on their personal circumstances. I'll be honest, some people are concerned about losing their job, but if they're not immediately worried about that, the smartest thing to do would be to make a complaint in writing. And the reason for that is because if they get terminated because of it, or if they're in some way treated differently because of that complaint, they would potentially have a retaliation claim. Okay,
and most importantly, where do we find you?
So you can call me at my number, 212-571-0700, or you can reach me on the internet, www.fishertaubenfeld.com.
All right, and you come back.
Absolutely, would love to.
All right. We have to take a quick break, but don't worry, we'll be back with more Today's Verdict right after this.
They call me MAXIE, but I prefer tripod. I was your above-average four-legged homie, and then wham, bam, minivan. Some people pity me. Now that's lame. I still run, fetch, and swim. And the ladies love me. I'm the ultimate wingman. Just don't ask me to high five.
Why don't you ever see elephants hiding in trees? Because they're really good at it. Yeah, I get it.
I'll never forget the day our landlord called and said, "Read your lease. No pets allowed." My owner tells him my dog ate the lease, but that didn't work. And now I'm stuck in a shelter. But this pit bull is ready for a new crib. I'm loving, loyal, and play well with others. So don't be intimidated by all my muscles, because the biggest one I have is my heart. That's right, I said it.
All right, welcome back to...
They call me MAXIE, but I prefer tripod. I was your above-average four-legged homie, and then wham, bam, minivan. Some people pity me. Now that's lame. I still run, fetch, and swim. And the ladies love me. I'm the ultimate wingman. Just don't ask me to high five.
Welcome back to Today's Verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at Today's Verdict. And don't forget to tweet me at David Lesh as well. Racial harassment occurs when an individual is receiving unequal treatment due to the color of their skin. Federal and state employment laws forbid making employment decisions based on someone's racial identity. We will learn all about racial harassment in the workplace, school, and housing area with attorney Joshua Friedman. Joshua, thanks for being here.
Thanks for inviting me, Dave.
All right, this is certainly a very hot topic. Tell me the types of racial harassment cases you've seen come through your office.
Well, as you said, it doesn't just happen in the workplace. It happens at school and it happens in housing. It's illegal in all three contexts. If you live in New York City, you're blessed because you have the best anti-harassment law in the United States, full stop. And any form of communication or conduct that a reasonable person would consider to be offensive based on their race is potentially a violation. It's a very powerful law. The question is, what do you do if it happens to you?
Well, when we're talking about racial harassment, is it just the color of the skin? Is it ethnicity? Like a Japanese American, I know, had issues during internment way back when, and what's the real history of this law?
Excellent question. The employment discrimination laws prohibit discrimination in the terms and conditions of employment, which are usually interpreted as the amount of pay or whether you get promoted. They don't explicitly prohibit, for example, the use of offensive racial terms. If somebody calls you, God forbid, the N-word while you're working, the law doesn't say it's illegal to do that. What happened was, in the early 1970s, as Title VII began to be implemented, the courts found that they were seeing more of these cases where it became impossible for people to work in environments because of the hostility. They were being called horrible names, exposed to horrible symbols of the Confederacy, such as nooses, things like that. And they developed a cause of action known as the hostile work environment. It includes sexual harassment. The remedies for a hostile work environment are the same as the remedies for ordinary discrimination. You can obtain back pay if you're fired. You can obtain emotional distress and punitive damages as well.
The harassment, is it overt, or many times is it behind the scenes that you know it's, I mean, give me like some examples now where the claims are being made and they're very suggestive of there's a racial overtone to it.
Well, unfortunately, if you're being subjected to racial harassment, you really aren't going to have a whole lot of doubt about it. One of the most common defenses you hear is, I was just joking, okay? But it's not funny.
No.
If somebody dangles a noose over somebody's head, that's terrifying. We see that conduct.
Right. Well, there was a case. There was a, I think it was an Italian restaurant that did that on. I think it was on First Avenue. Adamanelli brothers had some kind of issue, I thought, where they were using. There was a noose that was being thrown around, and his excuse was, I'm just making a joke. Well, it's not funny.
Not at
all. And it's scary, and it gave the employee a lot of nightmares, actually.
I remember that case, and I'm glad you mentioned that because not only nightmares, but what if you actually experienced that as a child growing up?
Sure.
There are plenty of people who grew up during the area where segregation was the norm who are still alive. What happens to them when they're re-traumatized on the job? The emotional impact can be terrible. You're familiar with the eggshell doctrine, basically. They've been doing fine on the job, and then all of a sudden something they thought had been eliminated from American society, we all think, or at least hope that it has, and bing, it happens again. And the trauma just causes them to fall apart.
These claims themselves, though, they go through, there's a process you have to file in terms of making sure that you're able to put forth your claim. Tell us a little about the EEOC. Let's talk a little bit about it.
Okay. Well, the first thing one should know is if you believe you're being subjected to racial or sexual harassment, speak to an attorney immediately. Do not call human resources.
Of the company, do not.
There are a few old lies. There's the check is in the mail, my wife doesn't love me, and the other one is human resources is here to help. Okay. Human resources is there to make sure that the manager who's pulling in $2 million a year, who's sexually harassing you, can continue to make those $2 million a year. and their investigation is intended to determine.
Is there an obligation, though, on the part of either the court later on or the EEOC to make that claim with HR? I mean, do you have to make do you have to at least say you've tried to mitigate some type of damages?
What I wanted to explain is, yes, but what you want is an attorney guiding
Doing it for you. I understand.
Because
Okay.
if you just come forward to HR, all right, what's going to happen is the minute you put it out there, they're going to put the word out to everybody who's witnessed this that you are not to speak to Josh. Say Josh is the plaintiff, okay? And that Josh is persona non grata, meaning everybody who actually saw this is now clammed up. All right, they're going to conduct their investigation. They're going to find that nothing happened, and miraculously, in 6 months, even though you've been performing well, your evaluation is going to go down the tubes, and you're going to be out of there. You need to collect evidence so that it's incontrovertible in advance.
And how would you suggest doing that? Do you walk over to your friend who happens to be working on the floor with you, who might have seen it? Do you say, "Can you give me a statement? Can you take some?" I don't know.
That's exactly right. Why not? Before your employer gets word of this, with the guidance of an attorney, what you want to do is approach people whom you trust, who are friendly, okay? Let's say it's racial harassment and the person is of a different race. They may be very offended by what's happening to you. They may care about you. Our firm gets written sworn statements day in and day out from these witnesses, and once you have that,
They can't recant.
not only that, but the company can't ignore it and they can't blame the victim.
Right, which is the most important thing.
The other thing is that it's illegal in New York secretly to record, and these harassers have something wrong with them.
Yeah.
There's a profile. They can't stop themselves. Your attorney should give you advice on this, and if you don't feel comfortable doing it, don't do it, but you can record.
Where can we find you?
888-369-1119. My personal extension is 4, and I answer my own phone.
All right. This is important. I mean, this is a very important subject, and certainly in today's environment, with everything that's going around with sexual harassment, racial harassment, we're not putting up with it anymore.
I just want to say that the advice that I've given on racial harassment is doubly important in sexual harassment. Approach it the same way.
Thank you. Well, that's all the time we have for today. I'd like to thank our guests for joining us, and of course you, the viewers, for watching. If you missed any part of today's show, be sure to check it out at www.bronxnet.tv. Also remember, if there is a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag #AskToday'sVerdict. From myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach your verdict. We'll see you next time.